Good evening, everyone. Welcome to this very special panel discussion on the value of legal education. My name is Anubhav. I'm an assistant professor at the School of Law, BML Munjal University. So today we have a very special panel for you, and we have gathered to discuss actually some very specific questions, which I would be asking everyone, of course, but in general, we are going to discuss the value of legal education in terms of the potential of legal education to contribute to diverse careers. Then we are going to discuss whether law can or legal education can be authentically interdisciplinary. We would also be having a discussion on what or how should students and even teachers navigate their law school journey. So these are some broad questions that, of course, you would be reflecting on. And before I move forward, what I'm going to do in this introduction is that I'm going to tell you a bit about the panelists. I'll introduce the panelists, and then I will tell you how we are going to proceed. So I'll just give you the flow of events. So allow me to introduce our esteemed panelists. I'll go in alphabetical order. Let's begin with Mr. Harsh Poddar. Mr. Harsh Poddar, he belongs to the 2013 batch of the Indian Police Service and is born on the Maharashtra cadre. He is presently posted as the commanding officer of the State Reserve Police Corps, Amravati. He has served in some of the most challenging jurisdictions of the country in his previous roles as SP of Bid, DCP of Nagpur, and additional SP of Malegaon. His work in Bid in the management of COVID crisis was in fact recently featured as a case study in the Columbia Public Policy Review. He's also the youngest recipient of 2018 G-Files Award for exceptional contribution to good governance. He is a recipient of the Scotch Order of Merit for Police Services for his de-radicalization initiatives that have been replicated across Maharashtra. Coming to his education and qualifications, he has completed his graduation in law from NUJS in Calcutta. Thereafter, he went on to do a postgraduate degree in international law at the University of Oxford as a British evening scholar. He practiced corporate law in London with the Magic Circle law firm before joining the IPS. Welcome, Harsh. Let me now introduce Ms. Ira Chadda Sridhar, who is a PhD candidate at the University of Cambridge and a Cambridge International and King's College scholar. She's also a lecturer at O.P. Jindal Global University. And prior to her PhD, Ira completed her LLM at Cambridge in 2019 and a BA LLB at the West Bengal National University of Juridical Sciences. Her research interests are the philosophy of law, moral and political philosophy, and law and language. Welcome. Let me now welcome Ms. Kritika Ashok. Kritika Ashok is a JSD candidate at the University of Chicago Law School. She is also an assistant professor of law at the Jindal Global Law School. And although she's currently on leave to complete her doctoral studies. Her doctoral research is on the legal profession in India. She's focused on understanding the role of the Supreme Court lawyers as members of the professional class and as participants in a politicized judicial sphere. Her research interests more broadly are in the area of judicial politics, constitutional law, and property law. Welcome. Dr. Moez Tundawala, he completed his doctoral studies at London School of Economics and Political Science and successfully defended his PhD thesis entitled In the Shadow of Swaraj, Constituent Power and the Indian Politics. Before this, in 2011-12, Moez read for his LLM at the School of Oriental and African Studies and received the Best Dissertation Prize along with the distinction in all courses that he registered for. He had earlier completed his BLB honors from the West Bengal National University of Juridical Sciences. All through his academic career, Moez has been a recipient of prestigious scholarship, including a fully funded scholarship for the LSE for PhD, Felix Scholarship for his master at SOAS, and the Microsoft Intellectual Property Scholarship during his final year at NUJS. Lastly, I would welcome Mr. Prasanth Dhar. Mr. Prasanth Dhar is a counsel in the banking and finance practice at Trilegal with a broad range of experience in banking, financial restructuring, securitization, and loan sale mandates. Prior to joining Trilegal, Prasanth worked for many years in the finance practice of a global law firm in London advising on high-value emerging market transactions. Prasann read for his undergraduate degree in law at Nalsar and holds a BCL from the University of Oxford, where he was a field scholar, and an LLM from Harvard Law School. He's qualified to practice law in India as well as England and Wales. So with that, I welcome all of you. Now, let me just move on and inform you about how we are going to go about this. After this brief introduction, I would first, Professor Barua would be setting the context and providing an introduction, after which every speaker would get about 10 minutes to put forward their first remarks, their initial remarks, and this substantive portion would be for about 10 minutes for each speaker. So after every speaker has spoken, then we have a Q&A session, which would last for roughly about 25 minutes, followed by the vote of thanks. So may I request Professor Barua to take lead and set the context for the event?
Thank you very much, Anubhav, and thank you very much for all the panelists for joining us today. The value of legal education is something which we thought is worth reflecting on, especially because we are a new law school. We are still charting out our course, and we immensely benefit from the experiences of extraordinary minds who have gone through legal education in India and abroad. So as we all know, that the value of legal education is sometimes doubted, and recently, there was a debate in Cambridge, which we all, hopefully listened to or read about, where a judge of the Supreme Court of the UK doubted the very value of legal education in terms of saying that it's a lost opportunity to study something else if you wanted to practice law. And legal education has little to add to the skills that you need to practice law. But of course, we know that legal education caters to a number of diverse careers, as the panel represents today, and therefore it's worth thinking about the different ways in which it can add value. Sometimes the value of legal education is also overstated. After, at least in India, after the national law schools, gained prominence, bright minds who would have otherwise gone to other streams have gone into law and have emerged, to shape successful careers and unconventional ones after their legal education. But we have constant complaints both from the bar, academia, and corporate legal practice that the 5-year law schools are not producing lawyers who can come in as ready to practice law or to contribute to different sectors of the economy. They have to learn on the job. We also hear complaints about the lack of quality faculty, which is really, something many of us might have experienced on the one hand, and on the other, we see that, there's a boom in the number of law colleges that have opened in the country, and people now worry about the quality of students too. So the context is that I think legal education has come to a stage where we ought to reflect both in terms of how it contributes, how it can contribute to the future, and whether there is just too much experimentation or talk without bearing much fruit. So the panel before us today, shows how there have been brilliant legal minds who have come out of the 5-year, law school system and have charted both conventional and unconventional careers. And therefore, I think that whatever it is, I hope they have emerged out of the 5-year law school, experience unscathed. But whatever it is, there seems to be, value that legal education adds. So at the BMU School of Law, as one of our keynote speakers in a recent faculty retreat said, Dr. Sudhir Jain, who is the director of the IIT, of IIT Gandhinagar, said that all institutions run on, a balance between, 3 concepts, which is quality, quantity, quality, resources, and time, whereas universities are one which run only on quality, quality, and quality. And that is something which we take seriously. And we have held 2 law conclaves where we have tried to revamp our curriculum. We have a promise of revisiting our curriculum, not to tinker with the fundamentals, which I think are very important, but also to bring in new insights, which perhaps the legal curriculum has missed. And so I think that the panel we have before us is, wonderful opportunity for us to learn from their experience and to think about how we can shape legal education in a way, both at BMU and, contribute to others who are there in India and abroad, by setting examples of how we can both be experimental and not lose sight of the fundamentals of legal education. So I look forward to the panel discussion today, and I encourage everyone to share their ideas as candidly as possible, as controversial as they might be, as many of you are known to be, and I look forward to that. Thank you, Anubhav.
Thank you so much, Professor Barga. Now, as I've mentioned already, that the flow of event is such that we are going to go to each speaker one by one. And once the speaker has concluded, I request if anybody wants to pitch in, make a short comment, maybe around a minute or so, to feel free. This is an informal conversation. It should flow freely. So please don't hesitate in pitching it at any point of time once the speaker has spoken. So basically, so that, we can have variety of thoughts for our audiences, so that if there is even some dissent, that should also come out. So please feel free. And with that, may I request Mr. Harsh Poddar to go first for your initial thoughts. Thank you.
Thank you so much, Anubhav. I hope I'm audible.
Yes.
Let me just begin by conveying a very sincere note of thanks to BML Munjal University, and particularly to Preetham, who for a brief period was on the faculty of my erstwhile law school, NUJS, and an association that has continued for more than a decade now. I'm really, really grateful for this platform, and it's a tremendous privilege for me. I'll cut to the chase because I think the speakers have just 10 minutes, so I'd like to pack in as much material as possible. I recognize that I've been invited here in my capacity as a civil servant, and in that sense, having taken a path which is supposedly unconventional for a lawyer graduating from one of the national law schools of India. But having said that, that brings me nicely on to the point that I want to make in today's talk, which is that unfortunately or fortunately, our law schools, particularly Indian law schools, I think, have somewhat, in many ways, enclosed the discourse of legal education careers towards disputatious jobs. Or, we have gotten into a habit where we have started to perceive the education of law culminating always into litigation or some form of litigation or one of its many allied sectors. Now, what I would like to argue in my talk today is actually, if you look at the corpus of law, a vast majority of it, or close to 80 to 85% of it, does not consist of letters of the law which actually spawn dispute in any way whatsoever, but instead are actually either regulatory in one form or the other, or facilitative in one form or the other. And the caveat here is that I'm actually talking about the domain of public laws, which of course forms a very large component of the corpus juris of laws. Now, when I talk from the perspective of someone coming in from government, and in particular the permanent executive of the government, which is the civil services, the point that I would like to proffer is that the central part of your job, or the main mandate of the job, is the execution of the law. Or rather, I would qualify that by saying that it is the impartial execution of the law. That is the central plinth upon which civil services, governance, and indeed any career that deals with the execution of policy is concerned with. Now, given that that is the case, and I hope that everyone is with me until this point, I would in fact go so far as to argue that a civil servant is actually more of a lawyer than a lawyer in that sense, because the core of our job really deals with the vast gamut, the vast majority of laws that are not actually disputatious in one way or the other, but in some way facilitative as far as public policy or public law is concerned. Having established this fact, I'll next, the structure of my talk is basically this. What I'd first like to delve is about how relevant a legal education is to a career in government. And then after that, I'd like to talk briefly about the kind of skills that legal education equips you with, which are extremely useful in governance and government in any form, in one way or the other. To begin with, and here I'm talking about the limited career of the civil services as is understood through the UPSC examination. When you appear for the civil services examination, and presuming one clears it, you join the government, and the government is a pyramidal organization, okay? It's a vast organization, needless to say, but it is pyramidal. And the level at which you join the civil services when you're coming in through the UPSC is at the very apex. You're joining at a very, very senior level, irrespective of which service you're going into, whether it be the administrative services or the police services or the revenue services or the foreign service, etc. You are joining at the topmost echelons of a pyramid. And the pyramid is concerned with the governance of the country in various domains, depending upon which department you're in. Now, the reason why a legal education is crucial here is because typically the way work happens in the government is through the movement of files. And you can call that red tape, or you can call it whatever you want, but democratic government setups have not figured out a better process of governance rather than having a multi-layered decision-making process. Now, the way a legal education equips you is that it gives you an ability to be able to regulate, supervise, and ensure the efficacy of the ranks that are below you in this vast pyramid of government. So when a file is moving upwards, so from the desk officer to the section officer to the head of the office superintendent, and then moving on to your level, etc., you are actually aware of the legal technicalities of the file. Now, this does not necessarily mean that you are aware of the specific section or the rule that is to be applied with regard to that decision. For example, if the decision is to be taken with regard to recruitment of police constabulary. Now, needless to say, this is a recruitment that involves millions of people, literally. You don't necessarily have to be aware of each and every single rule and nook and cranny as far as the legislations with regard to recruitment are concerned. What is important is that you should be aware of the broad principles of law that inform that domain. This is something where a legal education is absolutely indispensable. And I think this is central to your decision-making process, which is what you are there on that position for. Now, this is one where a legal education really equips you. Secondly, another important perspective that is important for people who are coming in from a legal background into governance is the way you see the law. Unfortunately, many a time, law schools prepare us to see law in a very abstruse way. And it is encouraged almost in some ways in several law schools in India as well as abroad to consider the law as a very complex organism. The more complex it becomes, the more ideas you sort of encumber it with, the better lawyer supposedly you are. Unfortunately, in government, well, fortunately, I would say rather, in government, it is the exact opposite. It's the inverted, the circumstance is completely inverted. Here, what is important is when you're in government, what is important is a practical, solution-oriented understanding of law. So while the core of what law school is teaching you, which is the substance of the law, is very useful, that subculture of complexifying the law is not something that is particularly useful when you're coming in from law school. It is important in government for you to be able to actually break down the law into the simplest of alphabets and be able to use those alphabets to devise and create a solution for the most complex of social problems. Whether you're coming in to the administrative services or whether you're coming into police services and you're dealing with complex questions of law and order, it's not going to help you while dealing with a situation on the street or on the raw grassroots level to be dealing with what jurists have been saying about that particular situation or not. No, that's not what's required. Problems that you face in government are very different. Each problem is very different from another, and it's impossible to find answers to them necessarily in several tomes. So while you have a great understanding of law, it's also important to have a very practical and solution-oriented understanding of the law. And I think there is a great role that our law schools need to play in fostering that perspective. Third point that I want to make is with regard to the way the law operates or the way the law interacts when you are in government. Now, typically in law school, we are trained to conceive of the law within the discourse of a certain clientele. We see it as a means of advocacy where you are furthering a certain perspective. This becomes slightly tricky when you are in government because your clientele is all of society practically, from the topmost echelon of the social pyramid to the bottommost. And I'm almost drawn to Rawls over here, but without going down the lane of jurisprudence, what I will talk about is that all of society is your clientele, and you need to be able to come to decisions that are not just effective, but are also comprehensible to every rung of your clientele. You should be able to explain the legality of your decision, how it sits in rules and laws, and how it actually furthers the interests of society to your clientele. Now, this will not happen if, for instance, in my case, if I were to be talking jurists and commentaries and treatises in some rural village of Maharashtra. It doesn't work that way. In fact, you need to break down the sections and the black letter of the law for it to be digestible to the common man. So that's very important in government. And lastly, as far as this segment of my talk is concerned, which is with regard to policy making, civil servants at their highest level of seniority are also tremendously involved in policy making. This is one of those few careers where you are actually involved in lawmaking and play a very active role in it from your mid-career point onwards. This can only happen if you have a really good understanding of how statutes, for example, are interpreted, how other jurisdictions are achieving what you intend to achieve legislatively, and at the same time have an excellent understanding of the empirical side of matters, which is your data that is coming in from the field. Something that lawyers, I feel, or law students tend to ignore a lot. Field research and the importance of data that comes in from the field. And when I say data, I mean numerical data, not interviews, etc. Real representational data, because government has to deal with macro levels of data. That, I think, is an important perspective to bear in mind for a lawyer who is in government. I'll conclude. I think my 10 minutes are getting over. I'll just conclude by touching briefly on the skills that a legal education equips you with, which are particularly useful or beneficial to someone in government. I think the first thing is the ability to appreciate multiple perspectives. In government, because as a collector or as an SP or as an assistant commissioner or a deputy commissioner, you will be interacting with so many different interest groups of society representing so many myriad perspectives. It's important for you to be able to take all of those on board, appreciate them, understand them, and come up with a workable solution. It's simply not enough for you to give a high-flown speech about it that further aggravates that problem. You need to be able to take them on board and come up with a solution for that accommodates almost every view. That is the core job of a civil servant. Secondly, I think people skills are very, very important. Now, remember, in government, you cannot rule by writ or by mandate. You cannot simply pass an order and expect it to be executed on the ground. It doesn't work that way. There are multiple stakeholders, which are large representatives and which represent several complex interest groups. You need to be able to persuade them and bring them on a table and convince them that the solution that you are proposing is really the best possible course of action and the one that will take them further from the point that they're on at. So persuasion skills, which is something that law school instills you with, is another crucial skill that is important in government. And lastly, about communication skills. Much of government runs on communication. Like I said, be that communication within government, be that communication with other stakeholders, be that communication with the public and society. Almost all of government runs on communication skills. Unfortunately, law schools in some ways tend to breed a slightly elitist communication model. This is something that I think lawyers who are looking at a career in government would do well to breed themselves out of. You should be an individual who is able to communicate at many, many different levels. You should be able to communicate in tribal vernaculars. You should be able to communicate sitting in a South Mumbai conference room. You should be able to communicate sitting on the diplomatic high table. That is what makes you a civil servant. And this ability to be able to communicate at multiple levels is something that I think law schools need to work on a bit more. I know most law schools, including mine, National Law School, as well as the University of Oxford, they used to do a lot of work on pro bono and legal aid. These are skills that I think I have been able to bring somewhat onto the table when I myself did this career transition from being a lawyer to being a civil servant. I will just conclude by saying that having a law degree also brings you an immense level of credibility in government, not just in the eyes of the government organization, the government pyramid, as in your superiors and politicians, but also in the eyes of the public. The fact that if you can convince them that your actions are actually legal and are not informed by any kind of malafide or a personal agenda, and you're able to break down the law for you, wins you a massive level of acceptance as far as your decision making is concerned. Because remember, decision making is the main thing. The one flip side, however, and this is at a micro level for young lawyers who want to come into the civil services, is that unfortunately law as it stands today, either through the 5-year model or the 3+3 model, takes much longer to complete than a regular graduation. So when you join the civil services, you're typically of an age range which is slightly higher than the youngest of your batch, which in turn typically affects how far you're going to go in the civil services to begin with. But nonetheless, having said that, I think it is a fair trade-off, because the kind of skills that law school brings to you equip you in an immense and incredible way for a career in government. If there are any of those who are interested in careers in government, feel free to reach out to me. I look forward to any more questions. I apologize sincerely for having overshot my time to 3 minutes, and thank you very much once again.
Thank you so much. Now the floor is open. If anybody wants to make comment, wishes to differ, just wants to concur, please feel free. Please, Professor Barwa, go ahead.
So one of the things that struck me was this ability to give solutions, Harsh, and at the same time you said that it builds multiple perspectives. Legal education enables multiple perspectives, but intuitively sometimes people might think that legal education gives you the skill to make things to argue from different sides, and therefore necessarily the decision that you are giving may not be a solution. It may be a kind of decisive way of or rhetorical way of arguing something out. But I would be interested to know what you meant by, in your experience, that law education might give you this ability to give solutions rather than just argue from a point of view.
Yeah, so Preetham, I think in law school, we get accustomed to a perspective of thinking that every person is entitled to their opinion. And indeed, they are in one way or the other in a democratic or in a democratic society. But when you are in government, your own perspectives and where you're coming from matter slightly more than that, because the decisions you are undertaking are the ones that are going to get executed on the ground. In that sense. So for example, we are now in the midst of the COVID pandemic. The way civil servants are perceiving the solutions towards, whether you're going towards a hawkish approach of enforcing lockdowns, or whether you're going towards a softer approach of facilitating things more so, more often than not, you have to arrive at a decision which is somewhere in the middle and a combination of both perspectives. To answer your question, how we are differing from a law school is that here the decisions that you are taking are not just perspectives that are being argued for the sake of it, which will not have an impact on the ground. Here the decisions you're taking are actually going to get executed and will realize themselves one way or the other. That is not to say that this is that we are in any way living in a totalitarian scheme of things where one person's decision is going to be foisted upon society at large. No. That's not what I meant. What I mean is that you should be able to take multiple perspectives on board and come up with a solution. Normally, the perspectives that will be advocated before you as a civil servant may not be solution oriented, but would just further the cause of a certain group. You need to take that on board and just decide in simple terms that, all right, this is your perspective, but this is how we are going to go forward by taking all of these into, it could be a simple decision like whether you're, say, for instance, going to block a certain road or not. You have to take into account all of the stakeholders and what they have to say, and then take the decision about whether that road will get blocked. The difference is that you have the power, the executive power and the legal power to actually take the decision about whether to block that road or not. So that's where you need to be much, much more careful than while say arguing a moot court or arguing a debate in law school, where you're just furthering an opinion which doesn't necessarily have a ramification on the ground and on the lives of several people, perhaps.
Yeah. Thank you so much. Thank you, Harsh, for your response. Now, allow me to now move on to our next speaker. I'll request Ira to kindly take lead and introduce her to her thoughts. Thank you.
So, Hari, am I audible? Can you hear me?
Yes. Yeah.
So firstly, thank you so much for inviting me to be a part of this panel. I already sense that it's going to be extremely engaging, and I'm really glad to be here. So to take off a little bit from what Preetham said in the beginning about this debate that's been happening, I think in some form at Cambridge as well, about the idea that legal education has nothing to offer or very little to offer. And so I'm going to really, try to capture what I think, in my mind, legal education has to offer, and why my journey as to becoming now, let's say, some form of a legal philosopher is relevant in this entire picture. So I think that the one thing that legal education really offers, perhaps distinctively from other models of education that we have, is that it really manages to bridge some kind of gap or make a balance between theory and practice. And I think that's where the uniqueness of a legal education rises, because it is a vocational degree. It is a degree, geared towards practice, as my co-panelist also said, but it inevitably, in my opinion, at least, leads us to some theoretical questions. And those questions are often annoying when we encounter them. But in my experience, I still think they were very valuable to engage with. And so therefore, a career in academia makes sense, because there is a very large link I see between legal practice and legal theory, or questions of theory. So I'm going to just try to talk about why I think philosophical questions matter for legal practice, or why they're relevant for legal practice. And sometimes I struggle with having to justify this relevance in terms of legal practice, but I still think that this is an important conversation to have, right? Why is theory at all relevant to legal practice? And I want to break this down into three components. First, about lawmaking, second, litigation, and third, about the role of lawyers in politics and society. With respect to lawmaking, I think the role of theory was somehow, in my experience, undeniable. And the way that legal theory is taught and studied often has a certain degree of pragmatism rooted in it, which is similar to, I think, what Mr. Podar was also saying about, arriving at solutions. And we might, in academia, be slower in that process at arriving at solutions, or may have different solutions, as it were, to engage with. But that is still the commitment, I think, of legal academia. So when I was studying, for instance, a debate like surrogacy, it was easier for academics in different disciplines to talk about whether surrogacy is morally right or wrong, or what are the social forms that surrogacy takes in different contexts. But as legal academics, we were kind of tasked with this question of how does one regulate it? Does one regulate it? So there is a certain pragmatism infused with the questions that you ask, which then you hope will influence in some ways lawmaking, right? So when tough decisions have to be taken on substantive areas of law, I think what legal academics try to do is work through those questions and ask about whether legal regulation is helpful or not. so I think that solution-based approach is also something that I've encountered in academia, that I sometimes tend to be more solution-oriented than some of my other peers coming from other disciplines, like purely philosophy or sociology, where they're content, and it's actually, I'm envious of them at some point, that they're content with describing the state of things or understanding the state of things. Whereas for us, when we write a legal paper, we are in some ways dealing with normative questions of how should this be done or how should this be regulated. So I think that solution orientedness is present in some ways in legal academia as well. And then we hope that it can, in some ways influence lawmaking. But the second thing that I've been thinking about quite a bit is about litigation, and how do these questions of philosophy or jurisprudence really matter for litigation? This is a tougher question, but the way that I have experienced it in my in the course of my career is that I find that often cases that play out in courts are very interesting sites for legal theorists, right? Because there are what I think happens is that language becomes a really important side. So you have laws which are written, through words, and then often you have two sides of the case advancing different meanings of these words or phrases. And I viewed these disputes as some kind of games of language, which were very interesting to me, which is that, one side counsel is interpreting it like this, the other side counsel is interpreting it like that, and the judge picks which meaning of the word or which interpretation of the word they like or they agree with or they think is most inconsistent with the law, and then that becomes the law, that becomes precedent. So and this happens quite a bit, and I think that the way that practice gives way to theory is that at some point, the words aren't really defined enough. So you say, okay, suppose we're dealing with a case of cruelty. So, in domestic violence or divorce cases, often you have section 498A, which talks about cruelty, and then the section itself uses more words to define cruelty in terms of grievous hurt or injury. But then again, what ends up being debated in the court is, does this really constitute grievous hurt? And at some point, we're dealing with questions outside of the realm of direct legality, which is something that has always interested me, that there is no legal material at some point to resort to. And then what is happening in a court of law, right? Is this a discussion about language? Is this a discussion about moral questions or political questions? What really is happening at that point? And so a lot of what got me interested in doing legal theory was really the role of language in litigation, in legal practice, and how I feel that it's fairly understudied, at least in legal education. So in NUJS, for instance, where I did my BA LLB, we had one course which actually really took my interest, which was on the interpretation of statutes. And it was a course that nobody else really seemed, not many people seemed to be particularly taken by, but I found it extremely fascinating because it was on the relationship that, words have with interpretation. And I found that a lot of the cases that I was studying were one on these linguistic questions, which is what then attracted me to analytic philosophy of a certain sort, particularly legal and political philosophy, to understand what was happening in legal systems better. So I don't know if this is something, these questions of language are something that can help lawyers, be better lawyers, but I think that they can certainly think about what's happening in a court of law through a different lens if language becomes one of those lenses. And this is something that's always fascinated me. When you study interpretation of statutes, which is actually a component of jurisprudence courses sometimes in the West, that you have long analysis by Indian courts on the meaning of certain words. So that I remember teaching 3 different cases in the Supreme Court, I think in the 1960s, on the interpretation of the term vegetable under the Bihar Sales Act, right? So, and different interpretations of this term would read the different results. And the interpretations of the term were just reliance on either different dictionary meanings or different intuitions of what the judges thought vegetables were. And this wasn't a purely theoretical question. This mattered because, obviously people got exemption under the Bihar sales tax if they qualified as vegetable vendors or not. So again, I found a very interesting kind of link between these linguistic questions and what was happening in a court and the way people's lives were getting influenced by this. So that was another area where I personally found, questions of legal philosophy, which seemed to be somehow removed from legal practice to enter the debate. And third, to be very brief and so I don't go beyond my time, is that I think that there are deep kind of questions that you have when you engage in legal practice on the role of lawyers in politics and society. What, the kind of moral, often personal political dilemmas that one faces in litigation is actually something that I think legal theory has thrown light on, right? About what is this idea of who deserves a defense, right? Does everyone deserve a defense? If everyone deserves a defense, why does everyone deserve a defense? To what extent can we make an argument that we do not agree with, or we think that has, very problematic political ramifications in court just to get somebody off the hook? These are questions that, again, legal and political philosophers have shed light on, which were inescapable for me. One of the reasons that I couldn't perhaps, to be very candid, do legal practice, because these questions kept coming to me, and I thought that they're worth answering. So I think that this is the reason that theory comes into different forms of legal practice, and I think a legal education's value lies in the fact that it can bridge this gap, because it is truly one of the areas of a vocational area which is very intimately connected with different academic questions. So I think that's where the potential of legal education would lie. And I'm happy to, again, answer any questions on why any of this matters and about my experiences with this. Thank you.
Thank you so much. I think Ms. Sridhar has made a very compelling case actually on how theory can actually contribute to solutions in the field of practice, or just how it can contribute directly to practice. So thank you so much. Again, I would like to welcome responses from all our panelists. Please go ahead. Please go ahead.
Thank you. Hi, Ira. I just wanted to work with you in terms of getting an understanding of how academicians see government solutions, especially in terms of how does one put it? How much of ownership does one actually take as an academician to the solutions that one is proposing? And here I'm talking about coming from a legal background and having studied law as an academic for to a large extent. I used to always feel that at some level, I was not necessarily taking up ownership for the solution that I was necessarily proposing, which is something that in government you have to do all of the time, right? So if you've taken a decision, you could literally be affecting thousands, if not millions of lives one way or the other, in perhaps in a negative way. But you don't have the luxury of ruminating over those options of a solution. You have to come to a solution really quick, and that solution must really work. Now, how do you see this problem from the perspective of an academic? I mean, will the solutions that most of academia proposes, except perhaps at the very highest levels, does it get executed? Secondly, once it is executed, is there a personal level of ownership or accountability that narrows itself down to the academician who proposed it to begin with? Thank you.
Yeah, so thank you for that question. I think it's something that I've thought about a great deal in the last year, actually, quite a bit, because I do think that in academia, you do have a luxury, as you said, to be more removed, particularly compared to people in government, from certain decisions. While that's a luxury in some ways, I think it's also in some ways not a luxury, because you are pushed to engage with certain, so you don't have, the benefit of saying that this was necessary as much. So you have to be able to really deal with the principles of the question, and it makes it a little tougher to make a quick decision, certainly, and there is, I think, a burden on legal academics to engage much more with different scholarship to be able to come up with a solution or any such thing, and I think that's perhaps the importance of the process, that that is the role of academia in some ways in the worlds that we live in. And it's not, in fact, to make quick decisions. And I think that when academics end up making quick decisions, sometimes it can lead to really bad results, because they're not, perhaps equipped to make the same kind of decisions as somebody in government is. And B, that's not their role. Their role really is to be able to think through some of these things at, with the luxury of more time and with more research, and come up with, let's say, more detailed, kind of complex ideas as solutions. And about accountability, that's an interesting question. I, at least in my experience, have found that academics seem to want to hold on to their positions rather strictly and rigidly. So they do want to be held accountable, perhaps not in the same way as government, people in government, but there is this kind of, that I have suggested, that I've spent 10 years of my life working on this one idea. So academics, I don't think, are also as, tempted to let it go. And in fact, they sometimes, in my experience, defend it to the point of, where they don't need to anymore. You could just say there was an error. But I do think that there is this need amongst legal academics to be accountable to things that they suggest, because perhaps of the kind of time that has gone into, or the kind of, research that has gone into coming to that idea in the first place.
Great, that answers what I was asking, but I'll just give a short follow-up. How much pressure is there as an academic to actually make an impact, as in an impact that translates into something on the ground? Is this a pressure that academia faces at all? And if so, to what extent?
I can speak for myself personally. I'm sure everybody else in the panel would also. I'll just keep it brief, but I think I've definitely experienced this pressure. And I don't, sometimes I think it's beneficial, because it really holds you, like you said, accountable to other stakeholders in society. But also it really makes research extremely hard, because there's this constant need to justify one's role, justify the value of one's research. And that process, I find it interesting to ask how much academics in other disciplines get asked that, or perhaps maybe that question is a little more with lawyers, because or legal academics, because we're so close to the domain of practice. But I think sometimes I wonder, if we ask the same level of a question to people in other disciplines, and it's perhaps important to give legal academics also that room, because they're dealing with complex ideas and complex solutions. So not being asked that question is also sometimes, I would say, a good thing, in my experience.
Thank you so much. I think that's actually quite fascinating. That gives me a lot of things to think about. And I think which I'll hold myself back at the moment. But in the interest of time, so I would request our next speaker, Ms. Kritika Ashok, please take the stage. Please.
Thanks so much, Anubhav. Good evening, everybody. It's really a pleasure to be a part of this panel, and I just especially want to thank Preetam for inviting me today. The topic that we're discussing is actually very closely related to also my academic interests, because I'm working currently on the legal profession. And so what I'm going to try and do in the time that I have is to speak about the value of legal education and the 5-year program, not just in a personal sense, that is whether it helped me in my pursuit of an academic career, but I'd also like to talk about it a little bit in terms of its political economy. In other words, I think I'll kind of just briefly consider the implications of the structure of legal education for the profession and its relationship to capitalism. I hope that in the time that I have, I'm able to connect these two strands of thought. And to begin with, I think the question that underlies both these aspects is of whether law actually offers us a distinct disciplinary approach to the study of human society. So for my work, I've been interviewing Supreme Court lawyers, and like Preetam was saying in his introduction, it's really interesting that so many of them speak of their legal education so flippantly. They tell me that they learn everything that they know at their law chamber and or in the courts. And similarly, friends and colleagues in the legal academy, mostly doing interdisciplinary work, tend to be equally kind of dismissive of their legal education. So, I mean, I think it's really important to ask ourselves, what role does legal education play? And I mean, anthropological work on law schools suggests that legal education actually kind of inculcates students into a way of thinking where you're replacing complex, messy concepts like justice with more straightforward legal categories, like, say, possession and property law, or perhaps meeting of the minds in contract. Or of sort of imposing procedural constraints of relevance of evidence on personal narratives of loss and suffering. So it's perhaps a process of learning and unlearning that we as students at law schools may not always be aware of. And as law students, we may not learn the ins and outs of, say, the NDPS Act, nor might we know how to read the proclivities or the mood of a particular judge. But we are perhaps learning how to kind of drown out the noise of, say, the social and economic circumstances that perhaps lead to drug abuse, as just an example. Now, all the lawyers that I speak to speak of how lawyers tend to be very analytical, which is to say, you could perhaps throw a multifaceted socio-political issue at them, and they'll be able to run it through their legal lens and produce a relatively parsimonious issue in its stead that can actually be decided by a court of law. And one may be critical of this sort of simplifying consequences of the legal lens, but the role of the law school here cannot be understated. The law school, I think, plays an important role in imparting this rationality in the Weberian sense to the legal system by introducing students to this legal lens and in training them to use it. In doing so, the university as an institution is thought to diminish the power of the profession. In other words, while historically the profession almost exclusively controlled the entry and training of lawyers, in some countries at least, much of that power has been relinquished in favor of the university. In India, however, this has not really been the case, and top grades from a top law school does not necessarily translate into a successful career in litigation. So the question we really have to ask ourselves also, is whether the 5-year law school format has the capacity to challenge the power of the profession. We're nearly 3 decades now into this experiment, and I think this is kind of the right time to ask this question. The 5-year program was actually conceived with the hope of encouraging more law students to turn towards public interest lawyering by perhaps offering something more than an introduction to the legal lens, as I've been calling it. But ironically, the law schools have actually become sort of a supply line for corporate law firms. So this, on the one hand, kind of suggests that the power of the profession within the complex of the court has remained undiminished by the university. On the other hand, it also speaks of how the standardization of legal education achieved here, particularly through the proliferation of these 5-year law schools and their kind of inter-se competition, has also aided in the growing proletarization of the legal profession. And when I say proletarianization, what I'm really saying here is that increasingly lawyers do not own the means of production, right? Which is to say that they're essentially employees of law firms, by whatever name they may be called, rather than independent practitioners. Thus, I mean, the 5-year law school model doesn't seem to have weakened the guild-like nature of the profession on the litigation side of the practice, and has simultaneously perhaps strengthened the hand of capital on the corporate side. But none of this is to say that the 5-year program was not, or that it could not have been sort of a radical experiment, challenging both the form of legal rationality that services capitalism, as well as the traditional guild-like nature of the profession. And in attempting to offer an interdisciplinary study of law, it could have offered law students more than just that legal lens, and an education beyond what they might have learned through an apprenticeship at a lawyer's chamber. So, also then like kind of re-signifying the importance of legal education. However, I mean, interdisciplinarity does not mean kind of teaching history and corporate law under the same roof, merely teaching history and corporate law under the same roof, which is perhaps the most that has been achieved by the 5-year experiment. And I think as a result, what happens is the 5-year program really emerges as an efficient way to achieve your legal education, because you're saving 1 year. rather than as one that offers a distinct approach to the study of law. Instead, if perhaps over 5 years, students studied, say, criminal law or contract through the conceptual and methodological tools of history, sociology, or philosophy, I mean, maybe, you know, this generation of law students may have also redefined what it means to think like a lawyer. I feel like philosophy and political theory are still better integrated at law schools, not only, I guess, because of their pedigree, but because of the shared interests in normative questions. So there's always this turn to these disciplines when looking for first principles in analyzing law. But disciplines like history, sociology, anthropology are much less integrated within law schools, even though law is actually an important subject of study in each of these disciplines. And here, I mean, I kind of agree with Ira that some of this perhaps also has to do with the fact that they're more interested. They often are doing very descriptive work. And I don't mean to offer up the University of Chicago Law School as a model, because there's a lot that, you know, I disagree with. But a point of note is that their commitment to the economic approach to law is so ubiquitous that whether it's a course on crimes or trademarks, you will be introduced to this way of thinking. And this sort of goes hand in hand with thinking of law and economics as a distinct approach to the study of law. And I think a truly disciplinary 5-year program may have similarly offered an opportunity for us to develop creative and distinctive approaches to the study of law. And I think it would have simultaneously carved out a sphere for academic study. I mean, I think there's always the fear that this might result in kind of the results will be half-baked, that you'd have a person who's a half-baked lawyer and, say, a half-baked historian. However, I think, you know, if the intention is to be an academic, the undergraduate program, I mean, we should think of it as only the beginning. And if the undergraduate degree can teach you enough so that you have the means to decide where to go from there, you know, I would count that as a success. And speaking for myself, at least, I think I felt rather unprepared for my career in academics at the end of the 5-year program. But that said, I mean, despite my interests now in sociological approaches to the study of law, given that my object of study remains the law and the legal profession, I think my legal education actually has given me this unique ability to be both an insider and an outsider, and to kind of move between those roles. And I think also the other interesting thing is that structurally, I think there's a lot of similarities between legal and academic thinking. You know, when you this approach of like seeing a mass of evidence and then kind of skimming through that with, say, a particular lens to then generate an argument, that is something that you'd see in both forms of thinking. And you know, I think you also come in with an understanding, because of your legal training, that not all authority is equally persuasive, you know, and that's something that's very important also when you're doing academic work. And I think, you know, you also realize that there are no correct answers. There's also just a better argument. And I think some of these ways of thinking really help you in an academic career. So I don't think that my legal education was unhelpful. But I do think that these skills have held me in good stead as an academic, but I will still say that it didn't immediately lay out, in my mind at least, these various opportunities of pursuing an academic career. Yeah, and I mean, I'm happy to answer more questions on that. Yeah.
Thank you. May I request panelists to kindly respond, or if you have any questions that you want to put to her, please take it. All right. So I believe there are no questions or responses at the moment, but we'll come back to you, Kritika, and I'm sure I'll have a question for you at the end of when everybody else has spoken, actually. So thank you so much. May I now request Dr. Moise to kindly proceed and put his views forward?
Yes, am I audible?
Yes, you are.
Great. Okay. Thanks, Anubhav. Thanks, Preetam, for this invitation. Hello, everyone. So I am interested. I work in the areas of Indian constitutional thought, legal and political theory, issues of constituent power, sovereignty, and the concept of the political. These are broadly the areas in which I work. But so I would want to start by saying that I went to NUJS at a time when it was at the peak of its popularity, and it was widely acclaimed, and not without cause, as perhaps the best legal educational institution in the country during its time, when Professor M.P. Singh was the Vice Chancellor. And we had great teachers, many not so good ones as well, but great teachers like Preetham and many others, who really played a big role in shaping our thinking. But I would like to say that the best that legal education had to offer was in many ways not good enough for me. So now, why do I say that? I'm not a cynical, cynically dismissive of legal education, but I have a deeper point to make. Now, this debate that Preetham talked about, the assumption-Virgo debate in Cambridge, it basically asks this question: is legal education necessary for a career in legal practice? And I think this is not, for me, this is not a question, because this is not an important question. I mean, the problem for me is not the fact that the law is not relevant, but I would want to rather make a completely opposite argument, that the problem with law and the problem with legal education is precisely this, that it tries to make itself, it tries too hard to make itself too relevant for the society at large. It is too utilitarian, it is too object-oriented, and I think it shares with many of the other social sciences as well, that it kind of, it tries to make itself too relevant for society at large. And I think this is something that needs to be problematized, right? So when we, when I went to NUJS, one of the, at the orientation, and even later on, one of the expressions that was used quite a lot was that, we are here to make you into social engineers. Right? So where did this really come from? This thought that the law is there, legal education is there, we are students and we are supposed to be converted into social engineers. And I think this comes from a deep hidden underlying ideology of law in general and legal education in particular in a country like India, and more so in a country like India, but also elsewhere in the world. In the 20th century, mid 20th century onwards, in the time when the Constitution of India was made, that we need to use the law as a means to accomplish desired social ends. Right? So law is to be used as an instrumental means to accomplish desired social objectives. So you use the law to achieve social change. Right? So Granville Austin wrote his, the 2 volumes of Social Revolution. It is through the Constitution that we need to accomplish the social revolution, the social revolution in India, right? And in today's day and age, the much fashionable terminology of transformative constitutionalism as well. Also, this is the ideology which underpins it. Now, all great, you might say, but it generated a lot of excitement amongst us to begin with, but it completely wore out very quickly, and the reason why that was the case, I think, was because this ideology, wherever there is ideology, there is always a supplemental fantasy which accompanies it. Right? So ideology was to use the law to achieve social change. But for a majority of students, they thought that I don't want to do this. I don't want to work for others. I want to work for my selfish self-interest, right? So in a way, this kind of produced counterproductively. It produced an apparently transgressive fantasy. And what was this fantasy? The coveted plush corporate job, right? So this is legal education is in a way caught between these two problems. One of ideology and the other of the fantasy. So what is the way out of this? I'm not saying that legal education is not helpful to academics, especially those who turn to the social sciences later on. In fact, it is very useful, right? So many people, as Peter mentioned, turn from law to other careers and other social sciences. Right? In fact, in many of these fields, the skill sets that the lawyers bring are object of envy and jealousy, right? So in social history and legal anthropology, which have kind of become quite big today, I kind of hear from my law friends who have moved on to these disciplines that the colleagues and their the fellow students, they're really anxious of the lawyer, because why? Because they feel that the lawyer can play this game much better, because what has remained of these social sciences, it's very data driven, fact gathering, and analysis of these facts and prosecuting an argument based on this analysis. All of this stuff the lawyers can do much better than the social scientists can. And so the lawyer is an object of great envy in these kind of fields of study. So this kind of this brings me to my point about myself as someone who's interested in legal theory, not legal theory specifically, but in Indian constitutional thought, legal and political theory, and as I just mentioned, concept of political. So I have a friend, who, as I just mentioned, they kind of switched from law to anthropology, and we're having this debate, and we keep fighting about this all the time. That this friend tells me that the ground is there's like an archive fever. The social sciences are gripped with an archive fever today. Right? So the most important thing is to be able to discover an archive. So this friend of mine tells me that why are you an armchair intellectual? What is that going to do? Why don't you come to the field? The ground is where the real action takes place, right? So this fetishization of the ground. So I have only two responses all the time. The first response is that I have a visual disability, and so the ground is inaccessible to me, and I'm not like a disability rights activist who's going to fight to make the change to bring about accommodations, change the non-existent special accommodation for persons with disabilities. And that's not my calling, right? So that's the first point. The ground is inaccessible to me as a visually disabled person. But the more important point is perhaps this, that maybe the ground is inaccessible to them as well, and they're just not aware of it. They're working with this illusion, this positivistic empiricist illusion that experience is all that really matters, and we can have access to the thing in itself directly, right? My submission is that the access to the ground is always mediated by thought, by ideas, and this is why you need to take the world of thought and the world of ideas very, very seriously. Now, having said all of this, and this is some of the last remarks that I would make. This is not to say that Ira talked about it, Pritam himself as a legal theorist, this is not to say that in law school, you don't do theory, right? You do a fair bit of that, but my problem over here is that normative legal theory and the way it is taught, especially in India but also elsewhere particularly in the Anglo-American world, is that it is it seems to be the only game in town, right? And that is where I really have a big problem. Normative legal theory is the only game in town, and what does theory do? I mean, and I would even perhaps say that this is, this is not part of the solution, but part of the problem, which in a way turned law towards being more utilitarian, right? So normative legal theory tries to just interpret what exists, right, as a kind of coherent whole, which has some integrity, and you can whichever placeholders, whichever categories you want to fit into them, these are just placeholder concepts. Now, my main point over here is, what you're interpreting that which exists, right? That which is there. But what about that which isn't there? You're interpreting that which is present. But what about that which is hidden or which is absent, or which, in spite of it being absent, it really shapes the way in which you interpret that which is your object of object of. So, a lot is often made of interdisciplinarity in legal education and so on. I think it's very much doable. I think too much is made out of interdisciplinarity also, because I think the law and social sciences can complement each other really well. They complete each other in certain ways. But I'm here to make a case for moving beyond this object-oriented utilitarian legal education, to have the courage, to have the bravery to say that, okay, let's try to think about legal education in, academics in general and legal education in particular in a more non-purposive register, right? Where, the task is not simply to change the world, but more importantly, it is to interpret it. And it's not only interpreting the world as you perceive it, but also interpreting the lacks, the gaps, the silences, the conflicts, the contradictions, and so on and so on. And and therefore my commendation would be, my submission would be that if you want to make legal education valuable, then what you need to do is you need to infuse legal studies with a very heavy dose of humanities and philosophy, understood in the broadest possible terms, not simply in the very reductive, narrow, restrictive, normative register in which philosophical discussions are always housed in, carried out in legal law schools, so that you could use, I'm not, I'm very eclectic in my taste, but I feel that you need to use you need to use humanities and philosophy not to supplement the law, but rather to sabotage its ideology, right? You in a way you need to use these other disciplines to short circuit and destabilize the certainty and certitude which lawyers and legal education are so confident about. Thank you.
Thank you so much, Dr. Moez. Once again, may I request the panelists to kindly take lead and make your remarks, short comments. Sure, please go ahead, Ms. Kritika.
Moez, I was wondering if you think that, in fact, social sciences or sort of the incorporation of social sciences into law schools could also be counterproductive in the sense that, it just adds to the sense of certainty, because at least that's something that I have noticed here. It seems like, because of also the interdisciplinarity, there's also this added belief that, now that we've also incorporated insights from, say, in the case that I'm thinking of economics, it actually makes the method of law actually even more useful and certain, if you know what I mean.
Absolutely. You complete each other, right? It's a complementary pair, right? It doesn't really allow the real social antagonisms to play out, and you don't really allow theory to make sense of the fundamental, social antagonisms that underpin the social political imaginary. So, I mean, that's absolutely my point, that, I don't think, the law and the social sciences go together very, very well, right? And what we need to be wary of in this interdisciplinarity talk that we so seem to be obsessed about these days is that, that's not adequate for me. Of course, we need philosophy, humanities, but we need to use them in a certain way that can allow you, that can equip you to destabilize the certainties and the certitude that lawyers seem to be so confident about.
Thank you so much for your response. We'll now move to the last speaker for the day, at least for the initial remarks. We have Mr. Prasant Dharwada with us. May I request Mr. Prasant to kindly take lead? You are on mute. May I request you to unmute yourself?
The usual story, isn't it? Well, thanks very, very much, Anubhav. And it's a pleasure to be and a privilege to be part of this panel. And thanks very much to the university for inviting me to this very interesting webinar. Perhaps of all of the speakers on this panel, I perhaps have most traditional job insofar as a law school is concerned. I'm a corporate lawyer, even though I did delve into some other aspects of academia many moons ago. So therefore, perhaps my remarks are going to be less intellectually charged and perhaps more mundane than those of my co-panelists who made some very brilliant interventions. And so if this talk or if my remarks are boring, please do tell me to shut up at any time. Just to kick off, and I think the way I have thought about this webinar sort of before joining was what are I guess the key facets of any education, right? Whether legal education, whether an education in history, whether liberal arts education, whether a sciences education, and then to think about what is distinctive about a legal education as opposed to humanities or a social sciences education, which perhaps are the closest comparators, at least the way many people currently look at legal education in terms of, it's most closely allied fields. And I think in that context, and speaking purely from the background of sort of what I do, I can't really speak for, other aspects that the other panelists have outlined in terms of academia and thinking about sort of ideas about legal education. I think 2 points. One is that there is the skills that you want to achieve, or the skills that a legal education needs to impart if you are going to be a sort of traditional lawyer, in the sense that I am a traditional lawyer, I'm a corporate lawyer, or if you are a litigator, you are a traditional lawyer. Perhaps Harsh in his occupation is a non-traditional lawyer because he executes law in a particular way, but he is a lawyer nonetheless. And again, those who are academics are non-traditional lawyers because they don't specifically practice law, but they think about the law as part of their daily activities. So from the perspective of someone who is a traditional practitioner of law, or who is thought of as a traditional practitioner of the law. I think the skills that you need to be a traditional practitioner of the law is perhaps at the core of what a law school must do. If you do not impart the skills that a traditional lawyer requires for the practice of what they do, you are not a law school. Then you are something else. And perhaps that gets a bit definitional. And so please excuse me if people believe that's a matter of semantics, but bear with me for the moment. If you don't teach what the traditional lawyer second, not all lawyers are the same. So even within the traditional practice of law, you could be a corporate lawyer dealing with clients who have a lot of money. You could be a corporate lawyer dealing with small and medium enterprise. You could also be a corporate lawyer dealing with retail investors who sue companies for securities fraud, right? You could be a disputes lawyer focusing on family law disputes. You could be a disputes lawyer focusing on corporate law disputes. You could be a disputes lawyer focusing on real estate disputes. You could be dealing with insurance disputes, labor law disputes, all other sorts of those issues. And the skills that you need, apart from the core skills that a lawyer needs, and I'll come to those core skills, are different. And unlike perhaps other jurisdictions where the law school is only 3 years, Indian law schools have the ability to take you beyond just the core skills that a law school needs to impart insofar as being a traditional lawyer is concerned, and give you those additional skills so that you are able to operate in the social space that you inhabit. Because the social space that you inhabit as a corporate lawyer acting for the largest banks versus the social space that you inhabit for being a disputes lawyer dealing with family law disputes or succession disputes is different. It's just different. And what the Indian law school can do beyond just the traditional stuff is to allow students to explore and give them the bouquet of flavors that allows them to see what other skills are required. And those skills, I can talk about those additional peripheral skills in a corporate law context and talking from my own experience, but I'm sure the skills which I need, or as a corporate lawyer dealing with the sort of clients that I do, are not the same skills that a family lawyer needs, apart from the core legal skills. So just going back to sort of brass tacks, I suppose, in terms of the traditional practice of the law, right? And this is perhaps a philosophical view, a disputed philosophical view, and it's perhaps that age-old tale of, depends on what perspective you has, but the way I see it, that if the law isn't a system of rules, then it is nothing else. Then it is something else altogether. So it's fundamentally a system of rules. It is many other things. It is 100 other things. It's a system of social control. It's a system of ordering societal relations. It's all of the other good stuff which legal academics think about. But at its core, it is a system of rules, right? And therefore, what the law prepares you and what a legal education must prepare you for is dealing with a system of rules. Now, we may disagree with what the rules are. We may agree with what the rules are. We may have views about how the rules will be ordered, administered, passed, created, and all of that. That's all well and good, but it is a system of rules. Fundamentally, what the law school and the skills that a law school, in my view, should impart, if a law school is worth its name, is the basic skills of knowing what the rules are. So that's legal knowledge, right? So what are the rules governing the creation of a contract? What are the rules that govern the constitutional relationship between the state and its citizens? What are the rules that govern the relationship between an employer and an employee? What are the rules that govern the transfer and the ownership of property, right? Second, the essential skill that a law school has to impart insofar as a traditional career in law is concerned is the ability to assimilate a complex system of facts, and in order to be able to distill them and be able to provide the advice to a client in the context of traditional lawyering. A traditional lawyer is someone who has clients on behalf of whom he or she makes arguments, whether before a court, whether in a negotiation room, whether in a contract. The third skill that a law school must impart, if it is to be a law school, is analytical ability. And some of the panelists have spoken about that analytical ability. And by analytical ability, I mean analytical ability in two contexts. One is the ability to deal with and understand the conflicts that occur in the rules and the complex rules that we in a place like India have. I have a view that India has more rules and more law than it should. And perhaps that's not the case, but that's debatable. And two is the ability to put those rules in context. So in the context of who you're dealing with and in the context of who your clients are, and in the context of who your client is dealing with. And fourth, most importantly is, not most importantly, but fourth is a law school gives you the ability or should teach you the ability to express yourself in a concise way, both verbally and in writing. And that is a skill that is absolutely essential for being a traditional lawyer. To be able to articulate what you are thinking and to be able to articulate a viewpoint pithily. So I think that's what I think in terms of what a law school must do. It's a very traditional view. I appreciate everybody else on the panel had very interesting views, but my views are perhaps more traditional. And in that context, I think the law schools haven't necessarily done particularly well. The law schools, I believe, should be careful before running, before they learn how to walk. And the walking, I think, is what I believe, what I feel I have just outlined. So I think part of it is the law schools need to solve some of the problems of the past, of law students' past, and the law school also needs to solve some of the problems of law students' future. Solving the problems of law students' past is solving some of the problems of our school education, where critical thinking and analytical reasoning are not part of our school education. Solving the problems of the future are knowledge, analytical ability, understanding legal rules in context. So I don't want to say, I think I've already overshot my 10 minutes. So I'm going to stop there. But in summary, sort of those are my views about the value of a legal education. And these fundamental skills are skills that are absolutely essential for law, but are skills that you can use in any profession. But they are not essential for other professions, but they are essential for a lawyer. I'll just end with that. Thank you.
Thank you so much. I think we have a few minutes left, so I'll just shoot a couple of questions, and I would request brief responses. So, Mr. Prasann, I'll just start with you because you've just concluded. You made a distinction between traditional and non-traditional lawyers, and in law schools, then by your definition, non-traditional lawyers are actually teaching you how to become traditional lawyers, right? At the end of the day. So, in that sense. Considering the framework in which academics teach in India, it does not allow you to practice. So you have to be in academia. If you want to be a part of academia, you have to be full-time. So that becomes a hurdle in terms of achieving that sort of experience. So in your understanding, how can we promote greater collaboration between academia and practice, so that even if you want to impart traditional lawyer skills, as you say, that could become more suitable for the students in light of what they expect and what they want to do once they graduate?
Sure. No, that's an interesting question, and I think there does need to be, and we can. I'll come to your question in just a second about what the collaboration between the practice and the teaching of law is and should be. But before I just get onto that, I should say I don't mean to imply that traditional things like the law of contract or the law of tort or the law of property need to be taught by people who actually practice those areas of law. Their point of view is very helpful because they help you with the second aspect of what I talked about in analytical ability, which is putting the rules in context. And that's very helpful for a young lawyer to understand. But somebody who is a non-traditional lawyer, who is an academic and teaches you what the rules are, they don't need to be a practitioner. You don't need to be a practitioner of law in order to teach what the rules regarding the practice of law are, because fundamentally you're just teaching what the rules are and how the rules are applied and interpreted by the court. That, in a sense, is quite boring, and that is, in a sense, very boring to law students. But it just is what it is. The collaboration between, the practice of law and the teaching of law of traditional legal subjects is to give life to those legal principles and legal rules. So there is, for example, let me give an example. A doctor needs to understand how the body works, but not every, and you don't need Dr. House, who understands where the chap got poisoned from and where the chap developed, or the person developed their medical problem for, in order to be a good teacher in a medical school, right? So in that sense, there is one aspect of teaching legal principles, which is you need to know them to be a traditional lawyer. And then you can always add someone who practices law to give life to those principles. But that, to me, is a secondary step. And my worry is that the Indian law schools don't even get step one right. Step one is where I think there is some degree of focus required prior to moving on to all of the other good things that panelists pointed out. So,
thank you so much. Now, I would just ask my last question, because I know we are out of time, and I would request very brief responses. I hope, if we exceed by a couple of minutes, it's not a problem. So just one last question, and which I would direct towards Ms. Kritika and Mr. Harsh. So the question is that, and this is from the point of view of 5-year law programs that we have in our country. Our university particularly, we are running 5-year law programs. And what I wish to ask you is that we discuss about language of the law, but here I want to ask you about language of legal education. And this also comes from my experience, where one of my students, they said that, they did not want to intern with a particular lawyer because they said that you may be exposed to Hindi when you're working, right? So when you are being taught in elite law schools, almost all national universities, you are taught in the English language. And would you agree that the fact that we are only taught in English, and the fact that the practice of law, at least at the district level, or the fact that within the government, most of the proceedings or even the files, they would be in the regional languages. Do you think language acts a handicap, especially for those students coming from elite law schools who then who just receive this culture shock when they leave the law school?
Whom do you want to go first, Anubhav?
anyone can, please take lead. I mean, Mr. Ash, you can go for it first.
Sure. Yes, Anubhava, to start with, I agree with you completely. And I've seen this firsthand. The mistake that many young lawyers tend to make is that they will be hitting the ground and be dealing with cases of the League of S.R. Bomai and Keshavananda Bharti, which is just not true, because Article 21 and Article 14 and Article 19 is simply not bread and butter work for a lawyer starting his or her career to begin with. I'm coming in from a state where the official language, for instance, is Marathi. The vast milieu of state regulations and state government resolutions and orders and rules are actually available only in Marathi to begin with. So if one is going to look at it from the perspective of a young graduate from a national law school who's coming out to say practice in Nagpur or in Pune or even in Mumbai for that matter, because there will be cases that will raise questions with regard to these rules. If he or she doesn't have an understanding of Marathi, and more importantly, doesn't make an effort to learn Marathi, which is the case I see with many young graduates, having that actual perspective that I've learned something better, then why should I go ahead and learn this, which is really unfortunate. This challenge is going to come up, and we definitely need to make young law students much more comfortable in vernacular languages, not just for the sake of states that converse with and deal with languages other than English, which by the way is the majority of the country, but also in order to be accessible to their clientele, like I said. I would also like to put an add-on over here. We've had about 3 decades of the National Law School experiment, and I think we can talk until the cows come home about how much the experiment has gotten derailed because it is no longer producing. In fact, it never did produce social engineers. But I think what is interesting, and perhaps Kritika can shed more light on this because she's coming from a law and economics background, is where are the jobs that this original idea spoke about having social engineers? I mean, we have 23 national law schools in the country today. That's 2,300 graduates approximately, if not more, being churned out each year. Where are they supposed to go in order to become social engineers? The non-profit sector simply does not have the absorptive capacity to take these numbers in. The civil services, and I can say this with a little bit less of guilt because I'm coming in from the government myself, is an examination with a 1 out of 10,000 success rate approximately. So clearly, the majority of a batch can't be going into the civil services. The only other option, therefore, is litigation. But are we seriously talking about 2,300 young graduates going on to litigate public law and important questions of public law each year? This was bound to happen. I mean, people were bound to move towards corporate law or careers in corporate law, which is where the jobs simply are. So I've never really understood, this coughing that constantly goes on among very senior lawyers and very senior academicians also about how national law schools have been a failure because social engineers are not being produced. Who were you producing these social engineers for, and where were the jobs that they were supposed to get? No one is, or at least the large majority is certainly not here to be in an uneconomical enterprise.
I'll have to interrupt you. I'm so sorry. But I'll just give the last word to.
Sorry, I'm done actually. So I think Kritika.
Thank you so much. I'm so sorry to interrupt. It's just that yeah.
Yeah, I'm going to keep my response brief, and I think I think it's a really important point that you're making, and I think it also speaks to why you see so many graduates actually turn to appellate courts. So you see a large number of law students from elite law schools practicing in the High Court or the Supreme Court. And if you listen to lawyers, they often are very critical. I mean, at least some of them are very critical of this kind of trajectory within the practice, because you're starting at the appellate level with little or no knowledge of how trial court work happens. And I think it's also not unrelated to this, our criticism of the courts in general right now. Like a very, many people take this view that, a lot of lawmaking in India is just happening in a very top-down manner, where the Supreme Court and the High Courts, not even the High Courts actually, like where the Supreme Court is making most of the law, right? And there's no work on improving trial court lawyering and, reducing appeals to the Supreme Court. So, and I think this actually the elite law schools are in a way just exacerbating that problem. And I think this is a very important thing to consider.
Thank you so much. I think it's been a very engaging evening for all of us and for our audiences also. So first of all, I would like to thank you. And with that, I would like to request Professor Preetham to kindly deliver the vote of thanks.
Well, I wish this could have gone on for longer. You know, I have been in several discussions on legal education, and frankly, they can be quite boring and drab. But here, you know, I wish we had more time. With Harsh started somewhere, and Moise, you know, on the other hand, you know, said something which in many ways complemented in many ways polar opposites of, you know, a vision for, you know, legal education. I wish we had more time to discuss that. Similarly, if, you know, there has to be the social sciences in legal education, and what Prasanna said, you know, will we have the time? And frankly, in between, I could see Ira, you know, speak both of the importance of theory, but not of the kind that Moise thinks, and talking about the power, you know, the ability to be practical in legal education, leaning towards Harsh, but you know, again puts us in a dilemma of, you know, the value of legal education. And Kritika's emphasis that actually the bringing in the social sciences does a lot of what the social science accuse the law of doing is, again, you know, an idea which usually in legal education discussions we don't hear. So I would, you know, thank all of you for bringing some excellent ideas to a, you know, conversation of legal education, which there's much need to be had, you know, I think over a longer course of time. I would seek your permission also to use some of the clips from our discussion. I'm going to take this in writing in various other legal education programs that we have to start thinking about legal education. And, you know, so thank you very much for actually making a discussion on legal education a quality one. And I look forward to engaging with you more, you know, on similar ideas and on other topics. And so from the entire BMU community, thank you very much. And we hope to have you again, hopefully on our campus sometime, to speak more on the, you know, areas that are of common interest. So thank you all.
Thank you so much, Preetham. It's been a privilege.
Yes, thanks so much.
Thank you. Thank you.
Bye.
Thanks very much.
Okay.